Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. Thanks for joining us. My name is Marnie Baizley, and I'm one of the lawyers at SpringLaw. I'm joined by Jessyca Greenwood. I'm excited because we've never done a webinar together, so we're looking forward to talking to you today. If you're one of our clients, you already know that we're employment and contracts lawyers at a virtual firm based in Ontario. And on that note, I will say this is an Ontario-focused webinar, but we have clients who operate in all provinces, and a lot of the content today is very transferable, but we do want to caution that it is Ontario-focused. So feel free to ask questions in the chat function, download the slides under the Handouts tab, and finally, for more info, feel free to visit our website, springlaw.ca. We have our award-winning blog posts on there, and they are fantastic. We get lots of great feedback about the content and how it's topical and timely. We also have a link to our monthly newsletter, info about our subscription program for employers, and all our DIY legal products. And what dovetails well with the content today is we have a investigation toolkit in progress, so that's coming soon for your DIY investigation needs. We also have an ebook called So You've Been Fired, which sets out a DIY approach for employees post-termination as an alternative to in-person legal services. I think those are all the initial admin details, other than the very riveting next slide, which Jess is going to read to you line by line.
Yes, I will definitely get to that disclaimer in a minute, but I'm here with my colleague Marnie today, and we're really excited to be presenting on this topic, which we are both so passionate about. And so moving on to the fun disclaimers, what we are going to talk with you about today is for your information only. It's not legal advice, and if you want to take a look at our legal disclaimer, there it is for your reading pleasure. And just before we get into the content of our presentation, we'll just take one brief moment to give a land acknowledgement. We are joining you today from Toronto, Ontario, and these are the traditional lands of the Haudenosaunee, the Wendat, and the Anishinaabeg people, and the First Nations peoples of the Mississaugas of the Credit. And we're happy to give that land acknowledgement. It's really important to us as well. So moving right along. Sorry, I missed queuing up the slides. My apologies. So there's the legal disclaimer for you. And now we'll get into our roadmap.
Okay, so high level, I just, one of the reasons we're passionate about this topic is because we have lots of clients, employers, either HR professionals, people ops wearing several hats with an HR function in their role, or even in-house legal counsel who come to us often and say, we've become aware of allegations or incidents of workplace misconduct. We're not sure how to categorize them. We're not sure what to do. We've never dealt with this before. And it's stressful. It takes an emotional toll on everybody, and it can be really expensive. And what we see is often after the fact, things that could have been done differently. And so we have a lot of clients that come to us thankfully beforehand for a strategic consult on how to handle, but we also see what happens when things go wrong. So this webinar is designed to help you to give some tools to deal with those unfortunate scenarios so you can get back to doing your job and helping as an HR business partner or whatever else you have going on, rather than these more these very stressful type of scenarios. So we want you to be able to, if ever challenged, later, if there's litigation, or if you're in a situation where you got to talk to your your leadership team and explain why you did what you did when these allegations or incidents came to your attention, we want you to be able to feel good about the steps you took and to know you did your job right, or did the best you could. So in terms of a little more detail, we're going to start with some discussion about when are investigations necessary, talk about some initial steps, principles, and considerations, like as when these facts come to these allegations come to your attention. Jess is going to go through some alternatives to investigations when you don't need to do an investigation. We'll talk about some best practices. This is when you decide you do have to do an investigation. Best practices for an effective and legally defensible employer response to allegations or incidences of workplace misconduct. And we'll go through a few mistakes to avoid, drawing largely on advice and scenarios that we've advised on where our clients have come to us. So we're trying to make this very practical and real life, and hopefully you'll never deal with these situations, but they do arise, unfortunately, especially in the workplace stressors that are around in COVID times currently.
Exactly. So we will talk now about when is a workplace investigation necessary. And I think what is helpful is to always look at what an employer's obligations are in the circumstances. And a very easy way to frame the test about whether or not you have to engage in an investigation is the safety of your workforce or your staff at risk? And when we say safety, we're not just thinking about someone on a construction site who might have something fall, but also psychological safety. So is there some form of harassment or abuse that's taking place in the workplace, in the work environment? And if those factors are present, it's likely that you will have to investigate. And some struggles occur when you don't necessarily have a formal complaint being made, but there's murmurs, there's gossip, there's innuendo that someone is alleging that there's a toxic workplace or that employees are leaving at a high rate and there's a lot of turnover. Those may be indications that an investigation is necessary. So in terms of being the employer, when you become aware that there's some form of harassment, discrimination, or violence, that is going to require you to take steps and investigate. And obviously, the more serious the allegations, the more serious the response needs to be. So if someone has committed a crime, has assaulted another employee, that's going to require that the employer take swift steps to deal with that. It may require police involvement, suspension of the employee, and then taking steps to investigate and set your mandate for what this will look like. When you're talking about planning an investigation, you're not required as an employer to conduct a perfect, at all stages investigation. You're required to conduct what's reasonable, what's appropriate in the circumstances. And what we say is you do have to be proactive. You do have to make sure that you're moving things along expeditiously, but don't rush. Take the time at the beginning to plan out what this will look like. Oh, sorry. Okay. So in terms of your actual legal obligations, we've put them up here for you so you can see from the Occupational Health and Safety Act what the requirement is under Section 32. You also have Human Rights Code obligations to your employees to ensure that they are not discriminated against in any way. And what you're trying to avoid by investigating is you are avoiding allegations that the employer failed their employees, they failed in their duties. You also want to retain employees, you want them to feel safe in your workforce. All of that is very important for morale and for retention and ensuring that, that the employer is not attracting liability. Because of course, if an employee makes a complaint and it's not dealt with properly, the employee could move on and either report it to the Ministry of Labour, to the Ontario Human Rights Tribunal, or sue the company.
Okay, I'm going to talk about some further initial steps, principles, considerations when this kind of matter lands in your inbox or comes to your attention in some other way. Someone comes to speak with you about it. The duty to investigate under the Occupational Health and Safety Act that Jess just referred to is actually easily triggered. It's a fairly low threshold. And I want to point out that the language in the section of the Act refers to both complaints and incidences. So you might have a formal written complaint, you might have a verbal complaint, or you might just somehow become aware of incidences that might trigger the duty, that might be considered to be workplace harassment or workplace violence. So that the first assessment is, could this potentially fall into one of those categories? And in that case, yes, we have a duty to investigate. So it's a duty that's easily triggered, and that's important to remember. So in figuring out when the situation lands on your desk, you're going to look at how serious are the allegations or incidences if you don't have anything formal. You're going to assess the complexity and figure out who's involved in the organization, how many people are going to need to be involved, whether as a party, there might be one or more complainants, there might be one or more respondents even, or a whole group of witnesses. So what are we dealing with here? How complex is it? And that's going to drive, it should drive much of your planning. You want to consider each party's perspective too when planning the employer's response. And I always say it's a good exercise to put yourself in the shoes of both parties, and what would they hope to see, or what would you hope to see if you were in their situation, either as a complainant or a respondent. And I think that helps, especially if you are a member of the organization, it helps remove biases or predeterminations that probably do exist in some form or another. And you want to ensure that the fact finding is procedurally fair. That's something we're going to talk about throughout. And by thinking about how would they view this and what would they expect for a procedurally fair process, is not only the right thing to do, but it will help with this legally defensible response that we're trying to achieve through the process. You're going to be able to respond to challenges later to your process if you put yourself in their shoes and think about what they're going to want to see and hear. It doesn't mean you have to agree to everything they request, but really think carefully about what they're asking and why they're saying something they need is they might not voice it as something that's procedurally fair, but they might ask for something. Think carefully about what they're asking for and respond thoughtfully, whether it's a yes or a no, so that they feel heard and they feel that the process has been fair.
I'll just jump in there as well. Communication with the parties right from the beginning is so key, because it can lead to a lot of acrimony if the employer is not communicating with employees. So imagine there's an incident and one employee has voiced a concern. The other employee then may be removed from the workplace or be suspended, and nobody's talking about what's happening. This can also affect the morale of other employees, especially if you're in a small business. You may not want people to speak to each other about the incident, and you may want to have some controls to deal with that. So it's important to plan out what the messaging will be, both for the complainant and the respondent, and also thinking about the other employees and how this may impact morale. And anytime you start to float the word investigation, it can be very stressful for people. And one of the first questions they'll ask is, do I need a lawyer? Am I in trouble? What's going to happen? You'll want to think about how you will respond to that right from the beginning.
Yeah, it's a great point. We see all the time how this can send people into a tailspin as soon as the word investigation arises, or as soon as there's any discussion about workplace misconduct and how the employer needs to address it. So actually, can you just go back for 1 second
Sure.
know that I just wanted to flag what is appropriate in the circumstances is a really key phrase. It's basic. It's quite basic, but it's again, you'll hear it several times today. That's your guide. That's what you have to go back to once you decide an investigation is required. What's appropriate in the circumstances, and that should really drive your planning process. And I think you want to consider. We do this all the time, and this is a shameless plug here, but I really think they're effective, and they can save a lot of money and lost opportunity costs down the road by the time you pull your team in to figure out how we're going to, you have to be discreet all the time and figure out who you're going to pull in. But all the time spent on dealing with these things, I feel like we've done some very effective strategic legal consults where we help, first of all, figure out, we do a legal analysis. Is this triggering a legal obligation? And if not, here are some other options. And we will get into who are we dealing with, who are the players, what are the workplace dynamics, and it's our job to assess risk and give options. And then you go off and figure out what works for your workplace, because every situation is so different. in terms of impact on morale and so on. So I do think that the legal consult is, and I'm coming at this from a, after having seen expensive situations go wrong and leading to investigations that may not lead to the outcome you want, and everybody's frustrated at the end. Hopefully that won't happen. It's not always the case, but early planning and a strategic consult can really help map out how you're going to respond and help you if you're having to respond later about what process you took, and defend your process, frankly.
Well, that's the perfect segue into your pre-investigation considerations. So you're looking at whether or not your duty as an employer has been invoked if you have to engage in an investigation. It's always a great idea to go back to first principles and look at the definitions of harassment. It essentially boils down to any unwanted conduct or comments that either were or ought to have been known by the person saying them or doing them was unwanted, and it may have created some form of humiliation or been degrading. And that's comments and conduct that doesn't fall into discriminatory practices or bias or prejudice based on one of the protected human rights grounds. So if you have those types of definitions in mind, also remember that the intention of the person saying the offending comments or doing the offending act, it doesn't have to be that they meant to cause harm. In fact, their intentions aren't really relevant to whether or not that can qualify as harassment. However, context is specific and important. Context specifics are very important because what's appropriate in one workplace may not be appropriate in another. And so if you're dealing with first responders or other types of industries where there's a lot of jokes and humor that may sometimes be inappropriate, that may be tolerable in that work environment, but be totally inappropriate in another work environment. So really looking at what the culture of the workplace is important and assessing that. But if you do have to go down the road of investigating, then the next decision becomes whether or not that should be an internal investigation carried out by someone within the organization, or whether an external, neutral third party should be brought in. Some of the considerations that you may want to take into account is whether or not you have a person in the organization who's capable of carrying out an investigation. Are they far enough removed that there's no conflict? And it's not just an actual conflict of interest between the parties, but even a perceived conflict. And the higher up you go up the chain of command within an organization, the more likely you should have an external investigator. So if the allegations or complaints are about the CEO, or someone in the C-suite, you probably should have an external person come in and take the lead on an investigation. So the consultation that Marnie was talking about would be the organization having a discussion with a lawyer to get all these preliminary pieces sorted out so that you can proceed with confidence and know that you're taking the right legal steps. And also, if you have that consultation and you need to hire an external investigator, that's something your legal counsel can also help you with and help you manage to make sure that all of these pieces are documented, that your rationale for why you did what you did is documented, and especially in situations where there may be safety issues and someone needs to be removed from the work environment quickly. These all require strategic thought and a legal analysis and can be quite stressful. So it's good to have a trusted advisor on your side to help you get through that. All right.
I'm just going to reiterate some of the general principles of investigations that Jess and I have both touched on. But some of the cornerstones are acting quickly or expeditiously, if you like a fancier word, fairly and decisively. Again, these are highly charged situations, and you've got to come out of the gate with again, back to the plan, but get on it early and discreetly gather the people that you need to help make these decisions, and get a plan going. And when I say act decisively, we talked before about, hearing if you have requests from parties or even witnesses occasionally, consider those, but be decisive and provide a response for why you're saying yes or no, and then move on. And you've got to be mindful of balancing the scope of the investigation. You want to keep the scope as narrow as possible, but make sure people are heard too, because investigations can go off the rails and become, there's many rabbit holes, become expensive and time consuming and distracting and so on. So acting quickly, fairly, and decisively is important. Procedural fairness is the overriding requirement throughout the whole process, is key. I've already talked about that, but that's really, and putting yourself in the shoes of parties is really, probably the most important thing when, if ever challenged or wanting to defend how you approach things. And it's the best way for your best possible outcome too, being fair. Because the biggest challenges we see later from employees or parties who aren't happy with the outcome, they're challenging the fairness of the process most often in some way, whether, our fact finder wasn't neutral for whatever reason, there were delays, it wasn't being heard, there was lack of communication. So again, put yourself in their shoes and within reason, try to make sure you're doing what you would expect of the process if you were going through what they're going through. Objective neutral investigation, I've just spoken about that. That's very key. I mean, parties look at the fact finder and they may have things to say about that. And again, you don't have to grant every request, but be thoughtful when they challenge it. I'm going to talk about a couple workplace scenarios just as examples. There's a whole ton of ways that you might get requests by participants in an investigation. But for example, you might have a complainant say, I'm about to go into an interview, a respondent going into an interview, I don't really understand the allegations or enough about the allegations or the particulars of the allegations. They may or may not have legal counsel in making this request, but you need to, you might decide, yeah, we've sufficiently framed the allegations for you, and you might be satisfied this isn't going to be an ambush for this person. They're not going to be able to turn around later and say they didn't have an opportunity to understand what they were walking into. So that's an example that we see where you have to really think about what they're asking and respond appropriately and document how you dealt with this, because if you don't, or if you don't respond appropriately, more often than not, they'll challenge the outcome if it's not in their favor. The neutrality objectivity issue comes up, especially in small organizations where if you decide to go internal, somebody might take issue with who the decision maker is. And that person's never liked me. I used to report to them, and these are the issues that arose. You got to really think about those things, even if you disagree, because if they don't like the outcome, you can pretty much bet what their next step is going to be, and that can lead to litigation or another process where the investigation is going to have to be redone in that next legal process. So it's something you definitely want to avoid, expensive and not an ideal outcome at all. So those are just a couple of examples about sort of war stories about why it's so important to plan. And again, you don't have to have a perfect process, just a reasonable process, well thought out process. No, but perfection is not the standard, but be thoughtful about all of the issues. And no doubt if you have a planning session, you're going to think, you or your team are going to think of a whole bunch of things that you hadn't thought of had you just jumped in. And the other thing is you have to be careful not to write something off as just an interpersonal conflict. We see this all the time with these two, and just we're too busy to deal with it. We've had a couple conversations, and now we're moving on. Is that going to be legally compliant, or have you fulfilled your legal obligation? And just being careful not to just sweep something under the rug that in fact needs more attention. That's something we see too. You have to address these things and document how you've addressed them, even if you don't think they merit the attention, time and attention at first glance.
Jumping in there, what is not harassment and does not require a workplace investigation is complaints about performance management. If the company is legitimately giving an employee feedback or placing them on a performance improvement plan or engaging in performance management because there's an issue with the employee, that is not harassment. unless in the method it's delivered, it becomes harassing to the employee. So those are situations that require some thought and can often be delicate because the employee may feel harassed by their manager if they're being asked why they're not meeting deadlines or not turning in work when they're supposed to. But that is allowed. Employers are definitely permitted to performance manage. So it's important to kind of think about where those lines are. And picking up where Marnie left off is looking at whether or not your workplace has a policy about what should be done in the case of complaints, who they should be reported to, how they will be dealt with. Having clear policies in your employee handbook will be really key. And if you have that and that's placed out there for all employees in a proactive way, it will make dealing with these difficult situations a lot easier because employees will know what to expect if this kind of thing arises, that they will be treated fairly, that an impartial investigator will be appointed, whether it's internal or external. So we really do encourage you to think about your own workplace policies and what you have now and what you may be able to build on or improve to make sure that the structure is in place for a fair, impartial review of these matters.
Jess, I have one thing to add. Is a great point about performance management. It's not harassment. And on that, dovetailing with that is being rude is not harassment, and being disrespectful is not harassment. Usually, it's has to be. You have to look at the full context and the comments or conduct. But we get a lot of those, and that's improper for lots of reasons, and should definitely be addressed by an employer. Sometimes that's the first question too: is this person's just being rude or disrespectful, and let's figure out a way to deal with it. It doesn't require a full-blown investigation. So being rude and disrespectful is not actually illegal. It's very wrong, but it's not prohibited. It doesn't trigger an investigation obligation.
Right.
More common than we'd like to see.
Well, picking up on that, workplace conduct that causes low morale, that causes turnover, or may give the organization pause about whether or not they should keep a certain employee, perhaps because they are rude or disrespectful to their colleagues or not a good team player, that may require some form of an alternative to an investigation. And so when we say cultural assessment, we're looking at the culture within the workplace environment. It may be that someone needs to come in and do more of a review. And so that might be a consultant or someone like Marnie and I, we sometimes have been brought into organizations to interview employees past and present about morale and about turnover and about the leadership, and make recommendations on things, policies, procedure, training, things the organization could improve upon to retain employees and improve the culture. That is a really good way for a larger organization to address systemic issues. And it can lead to a lot of areas for improvement. It can be really helpful. So those are some options. There's also bringing in a coach for the leadership, developing a senior leadership team, encouraging them to have more communication, and really training your mid-level managers to understand what complaints look like, how to identify them, and how to bring that forward to the senior leadership to make sure that there's good communication between all the different levels within the organization. Remember, it is a liability for an employer if a middle manager knows about a complaint that would trigger an investigation and then doesn't tell anyone, and nothing is done about it. It's not dealt with properly. That can be a huge liability for the organization if that employee comes back and launches a lawsuit or makes a human rights complaint. So you do want to make sure that all of your managers are aware, because if someone is told, the whole organization is deemed to know about the allegations. You can also engage in mediation if there are interpersonal disputes between employees that you think can be fixed, can be addressed. And if there's real problems with rudeness or other inappropriate conduct, you can look at terminating that employee if it really is just a one-person problem. All right. I know we're very close to the end here, but we've got some best practices for you.
Yeah, we can zip through these last ones. So just a few suggestions. I think we touched on some of these already. Even if you're not the investigator and you've gone external, or if you are the investigator, these are important as well. You always want to ensure that parties and potential witnesses or any participants in the investigation maintain confidentiality to maintain the integrity of the investigation, but also to help prevent that kind of tailspin effect that we talked about when investigations are happening in a workplace. Confidentiality is so key. Take steps to prevent reprisals or allegations of reprisals. So, there should be no adverse consequences for somebody complaining about someone else's conduct or for participating in an investigation, and that should be kept in mind by HR and managers and anybody taking a leadership role in planning and managing an investigation. And this is something that we see go wrong after the fact, unfortunately. We want to be mindful of all internal communications about the investigation. So those predeterminations or biases you might have about certain employees, first of all, try to set them aside for a fair fact-finding process, but certainly don't put in an email something like, oh, Joe's up to things again, or here he goes again, or things like that. Those emails are, if there's litigation down the road, they are producible most often because they are not communications to legal counsel. They're just internal communications about the process or the people. So be very careful about how you're assessing the situation and what you're saying about it in writing and verbally. You don't want your emails to have to be produced in an affidavit down the road. This last bullet point about procedural fairness, I've said about 15 times already. So we'll skip that one and we can move on to the mistakes to avoid with Jess.
Absolutely. So we have some do's and don'ts for you here. I realize we're at our time and we have some questions. We'll encourage you to email us if you have questions about anything we've brought up today or about this kind of process. In terms of mistakes to avoid, Marnie just hit a highlight. Don't prejudge the situation. Don't decide as a team what the outcome is that you want to see for the investigation in advance. You've got to go into it with an open mind and make sure that you are balancing costs and efficiency with being thorough, ensuring that everyone gets a fair shake, that they are heard, that they get their opportunity to tell their side of the story. So definitely you want to move along efficiently, but make sure that you don't rush and plan it out. So we do have a top takeaways slide, which we'll leave you with, and just move right on to the thank you so much, and please contact us if you do have questions.
Thanks everyone for joining us today. Have a great day.